This is the American Law Journal.
The NFL concussion settlement, a good deal for the players, or is the field tilted in favor of the owners and the lawyers? Good evening, I'm Christopher Naughton. Welcome to ALJ. A Philadelphia judge and a group of attorneys have structured a $675 million settlement offer to ex-NFL players who were injured in the league. To settle or not to settle? That is the question. Gina Passarella with the Legal Intelligencer reports.
After years of controversy, the NFL concussion settlement is nearly a done deal. Nearly. For a league dogged by the specter of players committing suicide, who shot themselves in the heart so their brains could be preserved for examination. To the frontline documentary League of Denial, excoriating professional football for its secrecy about concussions. The NFL and many of its former players are hoping the worst is behind them. And all eyes are on Philadelphia. Federal Judge Anita Brody of the Eastern District of Pennsylvania has been hammering away at lawyers, both the leagues and those representing former NFL players, to come to an agreement.
She's a judge who clearly doesn't have a problem with, sending the parties back to the drawing board.
But at an upcoming fairness hearing, Brody must entertain arguments from two rival plaintiffs groups, both representing former NFL players. And it's likely to get sticky.
This case has been marked by, I think it's fair to say, a great deal of tension between the plaintiffs' lawyers.
One group, represented by co-lead counsel for the plaintiffs, Chris Seeger and Saul Weiss, say the settlement is good to go. The other faction, known as the Sean Morey Group, named for the former Eagle player, believes the settlement favors owners and lawyers, not players.
The NFL's getting off easy. They want to settle. The class action lawyers are waiting on a $112.5 million paycheck. They can't wait to settle, And they're
aside from the money, the issue is what injuries are covered by the settlement. Former players with Lou Gehrig's disease, Parkinson's, Alzheimer's, and dementia are taken care of. Those living with chronic traumatic encephalopathy, or CTE, a debilitating brain disease, are not.
They're making themselves heroes because, we're taking care of, these poor guys with ALS and Parkinson's. It's like, yeah, of course you should be taking them. It's obviously those guys should be taken care of. Yet you're not taking care of most of us. There's a lot of negative effects on your quality of life as a result of CTE.
CTE is caused by head trauma that at present can only be fully diagnosed after death. But doctors increasingly cite it as a primary contributing cause of behavioral conditions, mood disorders, and perhaps even violence in former NFL players. Under the settlement, living players with CTE stand to get little or nothing, which may explain why 200 former players or their survivors, including 6 Hall of Famers, have decided not to settle, opting out of the class and retaining their right to sue the NFL on their own. For the rest of the players, all eyes and ears will be on Judge Brody's decision. Their health may depend on it.
So I have trouble motivating, focusing, concentrating, and it's debilitating depression to the point where I can't leave the house sometimes for days on end. The more and more guys I talk to, I realize have very similar symptoms, very, very similar.
The NFL concussion litigation settlement covers potentially 20,000 current and former NFL players, includes hundreds of millions of dollars for class members, as well as the attorneys involved. Yet there are some class members, even those who haven't opted out or filed objections, who don't really feel like this settlement is going to cover their medical needs in the future. But they don't want to take on the NFL by themselves. So while this chapter may be coming to a close for the NFL and the players who feel like they're getting a fair shake from the settlement, it's an issue that many players are going to have to deal with for years to come. From the American Law Journal, I'm Gina Passarella.
All right, 3 guests weigh in tonight. Steve Olenick is a sports attorney with the law firm of Kantor Davidoff in New York City. He represents numerous professional athletes and NFL players. He joins us from CNN New York tonight. Sarah Spencer is with us on the set. She is a staff writer with ALM's The Legal Intelligencer, and she's been the newspaper's point person on the NFL concussion settlement. And Patrick Hruby is with us from Washington, D.C. tonight, contributing editor for Vice Sports, former Georgetown University professor, and contributor to Washingtonian magazine. He has written extensively on the NFL settlement since it first became news. And I want to be clear, folks, we did extend an invitation to appear to the attorneys who represent both the NFL and the plaintiffs in this settlement matter. They have declined to appear tonight. They have provided us with a statement, which we will read in just a few minutes. And some of these lawyers have actually appeared on the program. So, Steve, let me go to you first. I have to imagine that the reason we don't have plaintiffs' lawyers here tonight is that they probably didn't see much of an upside in appearing.
I mean, why would they? I mean, they have $112 million at risk. I mean, this is a large sum of money. You say nothing. You try to collect your check and move on.
Sarah, was there a gag order here? That's something that I'm not really sure if there was. At one point, I thought plaintiffs' attorneys don't want to talk because the judge said don't talk. What was your impression?
There was no gag order. In July of 2013, during the first settlement discussions, Judge Brody entered an order saying that the lawyers were not to speak about the mediation discussions, but it was not a gag order, and it does not apply to the case as a whole.
Okay, let's take a look at some of the numbers, because in some ways the numbers have been a little all over the map. If I understand this right now, the settlement is set at $675 million. Patrick, we had heard at one point it was $765 million. At one point I heard that Judge Brody, I think they were considering a $900+ million settlement. Your understanding is what, Patrick? It's $675, but without a cap.
It's a little bit complicated. Again, it's like a lot of things in this settlement where it seems like it's designed to be complicated and hard to understand. What we're looking at right now in the revised settlement, the one that's going to be in front of Judge Brody at the fairness hearing coming up, is that there are two sort of general funds. One is for something called a baseline assessment program. This is for testing, neurocognitive assessment. This is a $75 million program. That is capped. The second amount of money used to be at $675 million. Now that amount is uncapped. So in theory, the NFL's liability here is limitless. But in practice, when you study the actual settlement, you can see that the individual awards that players might receive are very much capped and subject to a huge set of offsets, reductions, and that's assuming they qualify. When you look at the way you have to go through to qualify, it's actually quite difficult.
So Sarah, no cap, but in some ways, the bean counters have done their work. So 675 is probably a pretty safe number.
Right. The actuarial reports that were released in September from both the co-lead counsel for the plaintiffs and for the NFL both came to the conclusion that 675 plus the interest that would accrue on the settlement over its 60-year life, coming to about $950 million, would cover the amount of claims. And I think they were expecting like 3,600 total claims to be paid out.
Well, here's a quote from Chad Levitt, former NFL player who Gina Passarella had the opportunity to interview last week.
$675 million over 60 years for 6,000 people. When you do the math, it's not a lot of money. The NFL is now making $10 billion a year. So a $675 million settlement is chump change. These NFL owners are laughing.
You know, on this program, on numerous occasions, we talk about big pharma settlements well in excess of $1 billion. $675 million for the number of players that Chad Levitt just referred to, for the number of years. Does it seem pretty paltry?
Oh, Christopher, this is a joke. The Buffalo Bills just sold in excess of $1 billion. And then, if you look at the New York Times, if you forecast it out, the NFL revenues in 2027 is upwards of $25 billion. Not million, 25 billion. And then if you look at the NFL's revenues as a whole last year, it's almost $10 billion. So to get off the hook of not even $1 billion, it's a joke.
And by the way, looking at this deal and looking what it takes to actually qualify for an award, I think it's very likely they'll come in under $500 million over the life of this deal. But let's remember too, insurance companies are involved here. They're actually in court right now suing the NFL and being sued by the NFL over who's going to really pay for this. It's very probable that some or all of the tab will be picked up by the NFL's insurers. I wouldn't be surprised if there's a clever way through clever accounting that the NFL could find a way to actually break even or even maybe make a little bit of money on this settlement.
So, Sarah, the other big bone of contention is the CTE, the chronic traumatic encephalopathy. And unless a player has died, you really can't diagnose for CTE. So it doesn't appear, as you saw in the feature report just a few moments ago, it doesn't appear as though the NFL is covering that really at all.
It's not. And it's only covering death to former players who died before the preliminary approval of the settlement, which was in the beginning of July. So that's one of the biggest bones of contention that the objectors have is, as science and technology advance over, the next several decades, it might well become easier to diagnose CTE in.
And even if it is easier to diagnose, though, it doesn't seem as though there's any kind of provision.
Well, that's exactly it. That's what they're concerned about. There's no way to collect.
Steve, why is that not there in the agreement? It doesn't appear as though they've come to the table in good faith, both with the numbers and with CTE issues.
Yeah, and I mean, I think this is kind of what the whole issue is. They're going to try to make it as broad as possible. I think it's very difficult right now, and it's probably still a little too early, but to your point, yeah, make it as broad as possible and then try to encapsulate and try to encompass everything so that, it doesn't subject themselves to future litigation, in which, you've already started to see with guys starting to opt out, but once again, the whole opting out process and then suing the NFL, you have to have pretty good deep pockets to take on the NFL, as everyone knows.
Patrick, it seems to me that I don't know what number would satisfy the Sean Morey group that's going to be going up against this NFL settlement in the fairness hearing this upcoming week. $1 billion, $2 billion. But I've got to think that it's as much about the secrecy as it is about the dollars.
No, I think you're absolutely right. I mean, the Sean Morey objectors, and really almost every retired player I've ever talked to, and most of these players that are suing, they're really motivated by two things. One, they definitely do want to recover for the damage they've suffered. And I think there's much concern about their families being taken care of if they can't work, if they get truly sick, if they have those mood and behavioral problems that we just discussed that cause your life to fall apart, that aren't even being addressed by the settlement right now. They want to know that there's some help there for medical care and medical bills. That's another thing the settlement probably doesn't address adequately for the majority of players because it defines brain damage so narrowly. The second thing they want, though, is that discovery. They want to know the answer to the simple question. What did the NFL know? When did they know it? Who at the NFL essentially betrayed them? Who put their health at risk? Who caused them to suffer unnecessary damage? Who at the NFL was hiding this risk? Who told the NFL's concussion committee to go out and produce bogus scientific papers saying things like concussions in professional football are not a serious problem and that players who are concussed can often be returned safely to games, the same games that they're playing in? And that kind of stuff's ridiculous. And I think the players have a right to know that. And the public too.
And Sarah, that's one of the issues about this settlement is that if it does get settled, we, the public, and the NFL players really don't know what the NFL may have known about concussions and the problems with concussions going back 10, 20, 25 years ago. So that whole issue that Patrick just brought up, what did the NFL know? When did they know it? We never learn that if the settlement gets completed.
Exactly, which I think is why the NFL was probably pretty pleased to get to reach a settlement so quickly.
So this fairness hearing coming up, I mean, can anything really budge here? What are the judges, and believe me, I don't envy Judge Brody in this matter. You've got two behemoths coming to the table,
right.
Two forces, two rather demonstrative forces coming to the table, and a judge is supposed to get a plaintiff and defendant to agree. In this instance, what happens if she can't?
Well, I mean, after the fairness hearing, she has a few very limited options. She can either give final approval to the settlement. She can send them back to the drawing board again, which she's done once before, so she might do it again, although I think that's unlikely. Or she can decide that, yeah, there isn't going to be any meeting of the minds, and then she is presented with the issue that was put on hold as settlement negotiations started, which is whether or not this is going to go to trial or if it's going to go to arbitration.
Steve, let me go ahead and read the statement from Chris Eager and Saul Weiss. Again, these are the co-lead counsel for the plaintiffs who are moving forward, would like to move forward with this $675 million settlement with over 99% participation. It is clear that retired players resoundingly support this settlement. Over the last several months, we have heard from countless retired players who are in dire need of these benefits, as well as those who take comfort in the long-term protections this settlement provides. If the settlement receives final approval, former NFL players will be able to take advantage of its benefits within months, unless appeals are filed that will indefinitely delay the start of these programs. And let me go ahead and just roll right to Chad Levitt here, because here's what he did. Even though he doesn't agree with this NFL settlement, here's what he chose to do.
So personally, I filed an objection. I basically attached my name to the formal objection prepared by Sean Morey. Sean, I believe, has since opted out. I did not opt out, and the reason for that is this is just too much time and energy and effort for me to take on the NFL myself.
And Steve, even though you don't really agree with this settlement, you call it a joke, you represent NFL players. Some of those players, if they come to you and they say, do I take the settlement? In some cases, you say yes.
You have to, Christopher, because if you start taking on the NFL and if you're an attorney charging $500 an hour, if not more, it adds up very quickly. And a lot of these guys, unfortunately, they don't have the means to actually pay. So like you almost have to. And some guys are almost forced to take it.
Normally, of course, when we talk about injury-related matters, we're talking about contingency fees. Plaintiffs are not going to take these matters on contingency fees in all great likelihood, correct? If they opt out, is what I'm saying.
Oh, yeah. I mean, that's, you start having a lot of guys that will actually, just try to take it on, but then it turns into an hourly, and then some of the attorneys may not take it on a contingency. I mean, you just saw that Brian Bosworth just filed a couple days ago. I mean, it'd be interesting to see whether his attorney is actually taking it on a contingency basis.
Interesting. So, Patrick, in some ways, for, hundreds, actually thousands of players, I mean, the NFL sounds, it's got that ring of too big to fail, too big to challenge.
I think that, look, the NFL is smart in this way. They understand the psychology of the players that played for them. They know, for instance, you read that statement from the plaintiff's attorneys, the class counsel, who at this point are on the same team at the NFL, trying to sell the settlement. They know that these guys feel a kinship to each other. They look at the sickest guys right now and they think to themselves, sure, do I really want to stand in the way of them getting help? Even though that means me accepting a crummy deal, that means I might not get help I need now, or get help later, or I'll get such a small sum, it's not going to be very helpful at all. In a way, they're using the sickest guys as emotional hostages. While I find that extremely distasteful, it is probably a evil genius kind of strategy to push this settlement through.
Interesting. But if some players decide to opt out, others stay in the settlement, it's settled. Those players are not going to be affected just because some opt out.
Yeah, exactly. And that's one of the things that the co-lead counsel, are saying is the reason to push this deal through is because there are all these sick players and they need access to the funds. If it goes to litigation, it'll be years.
Arthur Miller, of course, who is a renowned legal commentator for ABC News, Good Morning America for many years, wrote a very interesting article, and he said, for any player to opt out of this settlement and pursue litigation on his own seems foolish. It is highly unlikely that anyone going it alone would lose in court and end up with nothing. And although opt-outs and objections are common in class action settlements, any unsuccessful objector who appeals would hold up benefits for every retired player. And again, that's not people who opt out, those people who would keep this class action or this settlement from moving forward. Mm-hmm. The NFL has this sword of Damocles or the perceived sword of Damocles, mm-hmm. this arbitration clause, that the NFL, if they wanted to pull the plug tomorrow and say, okay, we're done, we're taking this to arbitration, they could do that, could they not? Well,
that's up to the judge. That's the motion that's pending in front of the judge. Right. And there was, she had arguments on it, over a year ago now.
Right.
Brought in all the big guns, Paul Clement, had arguments, and yeah, she hasn't ruled on the motion as to whether or not this is a case that could go to trial or if it'll be preempted and go to arbitration.
But what's interesting here, Steve, is that if the NFL calls the bluff of these players who simply don't want to settle, and they say, okay, we're pushing the judge to have this go to arbitration. We'll probably get an arbitrator who's sympathetic to our corporate designs. But that could backfire on the NFL, because then a lot of these cases would move forward even within arbitration. The rules of evidence aren't totally suspended. Due process is not jettisoned. Some of those things that the NFL knew, and when they knew it, would come to light of day, would it not, even under an arbitration agreement?
Yeah, they would. And what would make it interesting there, but the NFL may just say, hey, look, now you got to prove that causation occurred. And I think that right now, a lot of legal experts today, and if you start really looking at them, the players are forced to take this, and just because, the deal isn't that great. But the reality of it is, and we started to say this in the beginning of the program, unfortunately, and I think Patrick said it, what's the alternative? A lot of these guys don't have the means to actually take this fight the distance. So now that they're staring at a dollar amount where some people might be upwards of about $5 million potentially, they're willing to take it.
Right, because the proofs could be difficult. Imagine a defense counsel on the stand. Did you play Pop Warner football? Did you play high school football? Did you play college football?
Correct.
And maybe that's why Arthur Miller it's
Correct.
a good deal, go ahead and take it. But of course, as this unfolds, some of the NFL secrets, which have been hidden for years, now are coming to light. And we had an interesting conversation in our own staff this week about how some of this started to look a little bit like big tobacco litigation or big pharma litigation. And then, of course, we see in the New York Times a week ago, is football the next tobacco? The problem won't be the fans or even the moms, it will be the lawyers. And they've already started. Steve, what do you think about that as plaintiff's attorney?
Plausible.
I mean, can you see a scenario somewhere down the line where someone takes a tack? Again, we see these big numbers in big pharma. It's not for the personal injuries. It's the fact that these large corporations defrauded the American public. I mean, obviously, to take on the NFL, it's going to take a lot of time, a lot of money. Do you see them possibly banding together and creating some sort of small tour de force here that may make the NFL sit up and take notice?
I think that's what would have to happen. I mean, I think you're going to have to go down that road in terms of a fraud claim, just because I think in terms of the negligence, it's so tough and so difficult to prove that I think the NFL might be willing to take it on. But on the back end, there could be a PR nightmare if they actually did fraudulently disclose a lot of these issues that come to light over time. Mm-hmm. It's a terrible mess for the NFL, and in light of what's actually happening now with, a couple other players, Adrian Peterson, Ray Rice, the NFL, Roger Goodell, did he cover it up? Did he not cover it up? I think from a PR standpoint, if we can put this to bed and move on, I think they're willing to do that. But if you get that group that actually wants to potentially stir the pot a little more and go after the fraud claim, it's just going to take, hopefully a group together, like you said, to actually do this. And,
well,
a lot of resources,
took a generation.
a lot of money, it's a lot of time.
Right. It took a generation for plaintiffs' firms to finally pierce the veil of big tobacco. It eventually did happen. Patrick, what happens now to those players who get injured in 2015, 2016, 2017? I mean, is this not unlike picking up a pack of cigarettes in 1967 and now there's a warning label on the side? People before 67 had a cause of action. People from 2014 on basically are going to be out of luck if they have CTE going down the line 15, 20, 25 years from now.
Well, look, that's the idea here. I mean, the players right now who are active or who did not retire before the date of preliminary approval this summer, they're not covered by the settlement. And, legal experts will say they're out of luck going forward because there is an assumption of risk. However, I think there's an important question here, and it gets to the things we were talking about: fraud, talking about concealment, talking about what the NFL knew and what they didn't, which is, even now, what has the NFL actually disclosed to its own employees about the cognitive, mood, behavioral, the brain damage risks of playing football? I don't know what they've disclosed. I think they've put up a poster saying there can be long-term harm in NFL locker rooms. It's pretty vague. And I don't know what they're doing. You know, you see Roger Goodell go on national TV, and he's like, "Oh, we're going to defer to the scientists." He doesn't say anything. The NFL actually one time publicly, and this was years ago, one of their PR people said, "Well, yes, there is a connection between football and getting hit in the head and long-term brain injury." They haven't said anything since. So have they really informed their players about the risk? I don't know.
We're going to keep on this. We're going to take a look and see what happens in the fairness hearing coming up in just a couple of days. I want to thank my guest for joining me tonight, Steve Olenick with Kantor Davidoff. Joining us tonight from CNN Studios in New York City, Sarah Spencer, right here on the set with me, with ALM's The Legal Intelligencer, and Patrick Hruby, contributing editor for Vice Sports, who's written extensively on this. Thanks, one and all, for joining us on the panel tonight. For all of us here at the American Law Journal, thank you for joining us this Monday. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Scheller PC. Since 1977, its mission has focused on one thing: protect the rights of individuals harmed by others' negligence or corporate misconduct, representing people injured by dangerous drugs, faulty products, and whistleblowers in False Claim Act and qui tam matters. Blank Rome, a national multi-practice firm for over 60 years, with more than 400 attorneys in 6 states and the District of Columbia. Blank Rome's highly regarded employment law practice provides representation and strategic advice for critical issues facing employers in today's workplace. And The Legal Intelligencer, an American lawyer media company, and the oldest daily legal newspaper in the United States.